Show me.
Well, open your eyes.
I can't. Sir, take me to the hospital.
Calm down. You're at the hospital.
If I was, you would give me my identification so I can give it to the hospital.
Calm down.
You don't need it.
Car.
I didn't do anything. You're a woman. You're gonna treat me like this?
You're gonna get tied. Get in the car.
Listen.
Get in the car.
Get in the car.
I'm getting in the car. Okay, I'm in.
When the people who enforce the law decide to take it into their own hands, resignations, suspensions, and viral shame often follow. These four women learned the hard way that even badges aren't untouchable, and the only qualified immunity they had was immunity from common sense. On a frosty September night in Grand Junction, Colorado, Officer Tafoya of the Grand Junction Police Department turned a contractor's nap into a constitutional crisis, proving that not all heroes wear capes, but some definitely need better training manuals. Bradley Conley, a contractor hired to build a Dollar Tree in a vacant shopping center, learned the hard way that resting in his car after hours was a crime if your cop has a wild imagination.
On the night of September 5th, 2023, contractor Bradley Conley was resting in a vehicle after hours in the parking lot for the Monument Valley Shopping Center in Grand Junction, Colorado, which had been vacant since 2015 and was currently under construction. Mr. Conley was working on the construction of a combined Dollar Tree and Family Dollar store and had authorization to be on property after hours when Officer Tafoya of the Grand Junction Police Department noticed the vehicle in the otherwise empty lot.
Officer Tafoya rolled into the Monument Valley Shopping Center parking lot, a ghost town since 2015, and spotted Conley's parked truck. The scene: no smashed windows, no alarms, just a man reclining in his seat.
Okay. Do you have your driver's license with you? So, I want to verify that you are supposed to be here. What kind of store are you guys working on? Okay.
If you want, I can.
Okay, who's a good contact?
I'm him.
What do you mean, I'm him?
I'm the guy.
So, do you have any paperwork or anything? I know you might have a key. You said you could lock it up or open it up and stuff like that. Do you have?
She demanded ID, insisting Conley was trespassing. He calmly explained he was the contractor rebuilding the plaza. Keys to the building included. Tafoya, unconvinced, doubled down. She demanded that the man prove who he is or go to jail. Conley, a self-described constitutional rights advocate, declined. The standoff began.
Officer Tafoya argues that unless she can verify that Mr. Conley is permitted to be in the parking lot, he is trespassing. Under Section 18-4-504 of the Colorado Revised Statutes, which is the state's third-degree criminal trespass statute, quote, "A person commits the crime of third-degree criminal trespass if such person unlawfully enters or remains in or upon premises of another."
Backup arrived, and Officer Tafoya changed gears from ask questions later to cuff first, Google laws later. Conley, now shivering in a tank top, found himself in handcuffs, not for resisting, fleeing, or even raising his voice, but for existing near construction he was hired to oversee. Tafoya's reasoning? Trespassing. Never mind that Conley had keys to the building, tools on site, and 7 weeks of pay stubs proving he belonged there. Her backup, Officer Dressler, nodded along like this was standard procedure for a guy napping in a Dodge Ram.
If you just want to hang tight, I have another officer coming, so we'll just hang out and we'll wait and we'll just go through that. You don't have any weapons or anything in your vehicle?
Not one weapon
Okay.
in here. No.
Okay.
I mean, you know, ill will or no harm, and I don't respect whatsoever. But you're not going to get my. I promise you that. I'm not committing a crime. I'm supposed to. So it'd probably be best.
Body cam footage showed Tafoya pivoting to new accusations: an open marijuana container, a grinder in his truck, and illegal camping, aka sleeping in a car on private property. Conley, ever the trivia buff, noted Colorado's open container law only applies to public roads. Officer Tafoya's response? A blank stare and tighter cuffs.
You said you've been previously contacted by law enforcement. Have you been contacted by law enforcement
Here.
at this address? Where?
Well, yeah, they stopped by all the time. Not contacted. They just came through and seen how I was doing when I was working.
Well, that's completely different, right?
Yeah. Well,
Okay. Was that daytime or nighttime?
Nighttime and daytime, both. But I'm not answering any more questions, and I'm not talking to you.
Okay.
Enter Corporal Moore, the genius who called Life Community Church at 2 a.m. to ask if they wanted to press trespassing charges. The catch? Conley was parked in a corner of the lot the church technically owned, though no signs, fences, or divine interventions marked the boundary.
Other than that, I have nothing more to say, and you're not getting many. Or fingerprint reader or any of that. And there's nothing illegal in there. It'd be really nice to let me put on a sweatshirt right there. It's kind of chilly. Or just let me go.
So, you know, I know you don't want to listen to us and you're not going to, but
I'll listen to you.
this all could have been, like...
It could all been okay if she walked up and said, what are you doing? And I said...
The groggy church rep said, sure, unaware Conley's truck was 10 feet from the Dollar Tree he'd spent weeks building. Tafoya, now armed with a civilian's sleepy "I guess," treated it like a signed warrant. Meanwhile, Conley's dog whined in the passenger seat, likely wondering what was happening to its owner.
Vehicle.
So am I under arrest?
Yes.
I am under arrest?
Yes.
It's right there in my door.
And what is your first name, sir?
Bradley, B-R-E-Y. I still have it.
And what is your middle name?
My last name is Conley.
What is your middle name?
C-O-N-L-E-Y.
Tafoya slapped Conley with 2 citations, trespassing and the open container. She ignored the fact that Colorado's camping ban targets public land, not private parking lots, and that the marijuana charge evaporates outside public highways. Conley, now a human popsicle, requested a sweatshirt, to which Tafoya countered with a lecture on respect.
So, Dressel, did we put his property in the
your
vehicle?
phone and the things that we count in your pockets.
Of course it is.
In the bed of your truck.
morning for you request body cam. Everything that you've said, keep them on. They are on. Yeah, I know they are.
Alright. So I'm going to remove the handcuffs and I need you to keep...
The charges were dismissed extremely fast, as you'd expect. Conley's YouTube channel documented the debacle, racking up views from folks who'd never trust a cop with a flashlight again. He's now prepping a federal lawsuit because nothing mends a chilly night in cuffs like a courtroom payday. On November 21st, 2023, in Oswego County, New York, a town board meeting devolved into a constitutional clown show when Deputy Caitlin Gregory decided asking questions was a felony. Michelle Allen Gregory, a transparency advocate, found herself in cuffs for demanding meeting minutes, a crime apparently punishable by ego-driven policing.
Allen Gregory, the vice president of the New York Coalition for Open Government, attended a New Haven town board meeting in Oswego, New York. During the meeting, the board adjourned into executive session, and Ms. Allen Gregory spoke out of turn to ask if there would be minutes taken during the executive session. Town Supervisor Dan Barney, who has repeatedly been listed on the New York Coalition for Open Government's so-called naughty list for government transparency, asked Ms. Allen Gregory to leave the meeting.
The chaos began when Michelle Allen Gregory, vice president of the New York Coalition for Open Government, attended a New Haven town board meeting. When the board adjourned to a closed-door session, Michelle asked if minutes would be recorded, a reasonable query for a watchdog group leader. Supervisor Dan Barney, seemingly allergic to accountability, ordered her to leave. She refused. Barney called the cops, framing it as a disturbance.
Okay, alright. Well, let's just have you guys
He
answer.
told me I had to leave a public meeting, and then he said he called cops, so I was waiting for the police to come so I would not physically remove.
Shush. I got you. So,
Because I'm allowed to speak at a public meeting.
okay.
Are you with her, man?
Yes, thank you. Public resource.
So,
You want her
if we,
Can I get the,
yeah, if I want to have her arrested, can I do that?
No.
Deputy Caitlin Gregory arrived, body cam rolling, and approached Michelle with the subtlety of a sledgehammer. Michelle, seated calmly, explained she was waiting for the meeting to conclude. Barney claimed she disrupted proceedings by speaking twice. Gregory, ignoring context, demanded ID. Michelle declined, citing her rights. Officer Gregory's rebuttal: "You're being investigated for obstruction." Translation: asking questions is a crime.
Ms. Allen Gregory could not be convicted of trespassing. Likewise, it is highly unlikely that an additional obstructing charge would be warranted for her refusal to provide her identification to Deputy Gregory. Although Section 140.50 of the New York Criminal Procedure Law authorizes police officers to detain individuals based on reasonable suspicion of criminal activity and demand of their name, address, and an explanation of their conduct,
Gregory escalated, threatening arrest for refusing to identify, a charge as flimsy as Barney's transparency record. Michelle, shivering in a tank top, requested a sweatshirt. Gregory offered cuffs instead. Backup arrived, and the deputy doubled down. She accused Michelle of trespassing, despite the fact that Michelle had attended dozens of meetings without issue. The crime existing while informed.
officers even inform citizens why they are being detained or arrested, let alone provide them with copies of the relevant statutes. In fact, arrests can be considered constitutional even if an officer arrests an individual for a violation of one statute without probable cause, as long as there is objective probable cause to support a different charge.
Michelle's friends, Holly Bale and another woman, refused to abandon her. Gregory labeled them trespassers too, despite no lawful order to leave. Body cam footage showed Gregory patting down Michelle like she'd smuggled state secrets, not a wallet.
Other than that,
I just threatened you with arrest like 6 times.
For what? Again?
OGA.
No, that's violation of policy.
No, that's not what I'm placing
is.
you under arrest for. You're refusing to identify yourself, and that's what you're going to be charged with.
Please make sure she's safe.
Where's she? Okay, now you guys are leaving?
Please make sure she's safe.
She's going to be safe. Trust me. Yes.
Gregory's pièce de resistance, arresting Michelle for obstruction and hauling her to jail. The charges? Criminal trespass and disorderly conduct, crimes as real as Barney's commitment to open government. Michelle spent the night in custody, her dog whimpering in the parking lot, while Officer Gregory filed paperwork with the confidence of someone who'd never read the First Amendment.
No. Can you take my purse, Molly? Yes.
You don't want to say who you are, is that correct?
I said I would do that. Why are you taking pictures of me being arrested right now?
Don't worry about
That's ridiculous.
So right now,
I would rather you not get my purse.
Do you need
honestly?
anything else?
Do you want, what would I need?
do you want your cell phone and your ID?
I don't know what you just put in my pocket.
Your phone and your keys.
At arraignment, the judge dismissed Barney's request for a protection order and released Michelle. The DA later dropped all charges due to speedy trial violations. Bureaucratic code for "this was nonsense." Michelle and Holly filed federal civil rights lawsuits. Deputy Gregory's legacy, a masterclass in how not to police. Her threats, misapplication of trespass laws, and condescending tone now live rent-free on YouTube, a tutorial for aspiring liability magnets. On September 22, 2022, Cleveland Heights officer Carly Lewis activated her lights and sirens to stop a vehicle on Mayfield Road. The driver ahead braked abruptly, forcing motorist Demetrius Kern to swerve and narrowly avoid a collision. Kern parked behind Lewis's cruiser, intending to question her reckless maneuver.
Carly Lewis of the Cleveland Heights Police Department initiated a traffic stop on the vehicle in front of Mr. Kern's car that almost resulted in a three-way collision. Mr. Kern pulled over behind Officer Lewis and the other vehicle she stopped in order to speak with her about her driving, and the interaction that followed was captured by police body cameras.
1 second! 8-1 radio, stand by. Send me another unit because another party does not know how to yield to lights and sirens, and he's sitting here recording me.
Body cam footage showed Kern calmly explaining he hadn't heard her siren over his car's music. Lewis dismissed his concerns, insisting her lights and sirens were active. When Kern pressed for clarity, she shifted focus, demanding his ID without legal justification. Her backup, Sergeant Wolf, arrived and doubled down, framing Kern's inquiry as obstruction.
And sirens activated.
Okay, we got you on camera too. They can come get the car. You're violating my rights. Come getting. Who's getting what car? They can come. You're going to radio another car here. I got a male who's obstructing. No, I'm not. And, he's refusing to identify himself. So I'll take a report on it, but I need your ID.
Listen, talk to me. I understand you and I and that gentleman, we all just saw what happened, okay? I called for another person because I have a man getting out of a car walking towards me. You know how society is. I know how society is. Now listen.
Kern refused to provide identification, citing Ohio's stop and ID laws requiring reasonable suspicion of a crime. Wolf, undeterred, cuffed him for obstructing official business, a charge typically reserved for active interference, not parked Teslas. Lewis, meanwhile, waffled between apologizing and deferring to Wolf's authority, her tone a mix of uncertainty and compliance.
Kern was violating the law in order to detain and identify him. We will discuss whether the officers had reasonable suspicion to suspect Mr. Kern of obstruction later in this episode. But for now, it is important to recognize that unless reasonable suspicion existed that he had committed a traffic violation or criminal offense, he was not required to identify himself or display his driver's license.
The obstruction citation hinged on Kern's alleged failure to yield to Lewis's sirens, a claim his vehicle's cameras later contradicted. Ohio law mandates drivers yield to emergency vehicles, but also requires officers to drive with due regard. Lewis's abrupt lane change and near miss suggested her actions violated that duty, rendering the citation ironic at best.
Highly distinguishable from this situation, as Mr. Kern parked well behind the cruiser and the stopped vehicle, did not interrupt Officer Lewis while she handled the traffic stop, and waited until she came over to him to speak with her. Therefore, it seems likely that a court would find that Mr. Kern did not commit obstruction when he stopped his vehicle to talk to Officer Lewis about her driving. Additionally, a court would likely conclude that the officers did not have probable cause to arrest Mr. Kern for obstruction based on his refusal to identify himself.
Kern spent the encounter shivering in handcuffs while Wolf lectured him on respecting authority. Lewis issued the citation under protest, admitting she was following orders. Kern's repeated requests for a legal basis went unanswered, highlighting a gap between policy and constitutional awareness.
A few hours after the traffic stop, Mr. Kern filed a complaint against Sergeant Wolf. Cleveland Heights Police Chief Chris Britton investigated the complaint and ordered Sergeant Wolf to attend a de-escalation training session. Additionally, Cleveland Heights Mayor Khalil Sarin announced that as a result of this interaction, he established an oversight bureau within the police department to allow for executive oversight of the Division of Police.
Prosecutors dismissed the charge 11 days later, but the damage was done. Kern filed a complaint, prompting Cleveland Heights PD to mandate de-escalation training for Wolf. Mayor Khalil Sarin established an oversight bureau, acknowledging systemic flaws. Kern launched a GoFundMe for legal fees, preparing to sue for wrongful arrest, a case bolstered by his Tesla's irrefutable footage.
Establishes that an individual cannot be convicted of obstruction for merely refusing to identify themselves. Despite the fact that Officer Lewis repeatedly gave him opportunities to de-escalate the situation and let Mr. Kern go, Sergeant Wolf insisted that he be issued a citation because he was already in handcuffs.
Demetrius Kern's charges were dismissed, but the encounter exposed fragile egos masquerading as protocol. Officer Lewis avoided discipline, but became a poster child for reactive policing. Sergeant Wolf's training served as a bandage for deeper issues. Cleveland Heights taxpayers funded both the blunder and its cleanup, a reminder that sometimes cameras outlive tempers. On December 3, 2021, East Ridge, Tennessee, officers responded to a welfare check for a child at Haley Sherrard's residence. They found Sherrard and her son Devin sitting in a parked car outside. Officer Teddy Dyer approached, claiming he smelled marijuana, a justification to search the vehicle. Sherrard refused, asserting her rights, but Dyer escalated immediately.
Officer Teddy Dyer, Officer Candace Miller, and Sergeant David Myrick of the East Ridge Police Department in Tennessee responded to a call for a well child check at the residence of Haley Sherrard. When they arrived at the home, they found Haley's mother, Angel Sherrard, along with her son Devin, in a vehicle in front of the house.
Body cam footage showed Dyer threatening arrest if Sherrard interfered with the search. Tennessee law permits vehicle searches based on marijuana odor, but Sherrard's defiance triggered aggression. Dyer grabbed her, slammed her face into the car window, and yanked her hair while cuffing her. Backup officers watched, later deleting their body cam footage, conveniently purged post-incident.
Distinguishable from the smell of hemp, concluding that, now quoting, "Until our Supreme Court or our legislature determines otherwise, the smell of marijuana continues to establish probable cause for the warrantless search of an automobile. Accordingly, if a court believed Officer Dyer's assertion that he smelled marijuana, it is highly likely that it would determine he had the probable cause necessary to search Ms. Sherrard's vehicle."
Sherrard's federal lawsuit detailed excessive force, head slammed against the vehicle, hair pulled post-cuffing, and Sergeant Myrick's taser drive stun as she struggled to fit into the squad car. Officer Anna Simmons' report omitted Sherrard's warnings about her size, framing her as belligerent. The footage, however, revealed Sherrard's calm protests drowned out by Dyer's barking commands.
Car! I didn't do anything. You're a woman. You're gonna treat me like this?
You're gonna get tight. Get in the car.
Listen.
Get in the car.
Get in the car! I'm getting in the car. Okay, I'm in.
Although it is difficult to tell exactly what happened from the body camera footage, and Lackluster reported that the other officer's body camera footage had been quote-unquote purged, Ms. Sherrard's attorney detailed the officer's use of force against her in a federal lawsuit stemming from this encounter.
Sherrard's daughter, 15, was cuffed during the chaos. Devin, 18, confronted officers for manhandling his mother, earning himself a disorderly conduct charge. The family's crime? Existing while black in a parked car. Officers searched the vehicle, found nothing illegal, and confirmed the child inside was unharmed, rendering the welfare check a hollow pretext.
Its proper application requires careful attention to the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight.
Tennessee's plain smell doctrine allowed the search, but Sherrard's lawsuit argued the odor claim was fabricated. No marijuana was found, and her Tesla's unreleased dash cam likely contradicted Dyer's narrative. The department's history of similar lawsuits, including Dyer's prior excessive force allegations, painted a pattern of reckless policing.
To support a disorderly conduct conviction, based on the body camera footage of what actually occurred, it seems unlikely that a court would find that Ms. Sherrard could be convicted of disorderly conduct, or that her arrest was even supported by probable cause. As to the resisting charge, according to Section 39-16-602 of the Tennessee Code, quote, "It is an offense for a person to intentionally prevent or obstruct."
Sherrard was hospitalized, charged with disorderly conduct and resisting arrest. Prosecutors dismissed all charges in April 2022, but the damage lingered. The family sued East Ridge PD in federal court, settling for $110,000 for the minor daughter and undisclosed sums for Sherrard and Devin. Officer Simmons was fired in December 2022, only to be hired days later by Bradley County, then resigning mysteriously in May 2023.
Try to talk to him. 18. He's old enough to take a ride. He goes to the big boy jail. Listen, I want you to know how this would have went. Ma'am, I'm going to have to search your car. Okay, I didn't find anything. Guess what? Have a good night.
After Ms. Sherrard's arrest, the officers searched her vehicle and found no marijuana or any illegal contraband.
The lawsuit exposed systemic rot. Simmons mocked Sherrard's size with a "sucks to be you" quip, while Dyer's colleagues rubber-stamped brutality. East Ridge's 22,000 residents now fund legal payouts for officers who treat badges as bully pulpits. The department's training fixes a Band-Aid on a bullet wound.
Overall, the East Ridge officers get an F for using unnecessary force against Ms. Sherrard, blatantly misrepresenting Ms. Sherrard's conduct during the encounter in an apparent attempt to manufacture criminality and justify their actions, and seeming to take pleasure in subjecting Ms. Sherrard to both physical abuse and emotionally demeaning behavior. Officer Simmons in particular seemed to relish misusing her authority.
The Sherrard's lawsuit forced East Ridge to pay for its officers' cruelty, though no admissions of guilt followed. Officer Simmons' firing and rapid rehiring elsewhere highlighted law enforcement's revolving door for misconduct. The department's record remains stained, while the family's settlement, a small price for a city's reputation, proved justice often wears a dollar sign.